Dress code. Dress
So what?
Greetings, 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 greetings. It is I, King Clifford Jefferson, a citizen of Godfrey, the fifth Caliban Jew, son of folk, ruler of Jerusalem. I'm the reincarnation of King Edgar, the peaceful, which we know as Jesus Christ. It is May 25th, parts of May 27th, 2025, which is equivalent to the birth year 2975. I greet you in the name of my queen, Sister Godwinson from the house of Godwinson. I greet you in the name of Archbishop Belmont from the House of Belmont. I greet you in the name of all those who are members of the Third Temple English Church of England, as well as all those who are trying to get an understanding of what it is that we are here and called to do. Greetings to all who are going to join me today. This particular topic is called Trump versus CASA Incorporated, Supreme Court, and what they are not telling you about this case. Once again, today's lesson is about Trump versus CASA Incorporated, a Supreme Court uh, uh, appeal that's being reviewed by the Supreme Court as a result of Executive Order 1460. If anyone knows what that executive order is issued by Trump, we're going to discuss that today. But we're going to take our narrative from the Supreme Court review of the appellate court's decision, as well as the district court's decision, circuit court's decision on whether they should put a nationwide injunction by way of what they call a bill of peace in lieu of the birthright citizenship as established by the 14th Amendment, or does the Supreme Court lack the jurisdiction to grant such a relief to the so-called Trump, i.e., which would be the appellant in the state, or i.e., the 18 states that joined the suit, led by New Jersey, which will be the respondents in this matter. So we're going to review this case. This is part one. It's going to take two parts to review this case. So this is part one. Okay, so I want everyone to please pay very close attention to what's being said. Greetings, tribes and trusts. Respect to you as well. Hopefully today will be very educational about what true citizenship is and what they're not telling you about what true citizenship is, because there are two types of citizenship: just soil and just sanguineous. Okay? Just soil and just sanguineous. Just soil is being born on the soil, and just because you're born on the soil does not, in fact, make you a citizen. Then you have just sanguineous, which means those who are exclusively and inclusively are born by way of a mother or father or some type of ancestry that goes back to your race, ethnicity, genealogy, etc. So this is the topic before the Supreme Court in lieu of the controversy between the birthright citizenship that will affect each and every one of you by way of the Supreme Court. But for us as the English heirs and successors, we will be safe. All right. So with that, let's get started with this marvelous lecture. Of course, you know when we all go to court. Greetings, Brother McGarrett from the House of McGarrett. All right. A lot of times we have all been to court. All right. And court is where you're supposed to get the due process from, whether it's the law division, chancery division, criminal division. It all affords you due process of law, due process rights. Okay. Rights protected by the law. Hold on for 1 second. I got a call coming. Right, so I'm back. So we know that we all are familiar with the court system. Okay, that's the only way we are going to get some type of relief, remedy. Okay, that's the only way you're going to get it. And we know there are three divisions. Whether you're talking about Supreme Court, Appellate Court, districts, which are circuit courts, or state courts, law division, criminal division, chancery division, probate, whatever uh, jurisdiction uh, that governs the matter at hand in regards to some type of claim between parties, the end result will be in a court of law. Okay. Now it's very important to understand why this court law is important, is because this is where you are informed of your rights. And America is a melting pot of different nations and different nationalities and different cultures and different customs. And all of this is determined by the language in which they speak. Okay, it's determined by the language in which they speak. Okay, all court systems are regulated by state statutes, presidents, and the Constitution, and any other enactment that's created as an act of legislation or administrative law, etc. Okay, it's very important to understand that. But the reason why I'm saying this is because whether you realize it or not, the laws were written in a language that the people can receive the most favorable reply. That's why whenever you go into a courtroom, the first thing they ask you, you have the right to remain silent. You got a right to a trial by jury. You got the right to counsel. They also say that if you don't know your rights, you got the right to an interpreter. Okay? An interpreter. That means every person that does not speak the language of the court needs an interpreter. And the language of the court is English. No matter what court you go to in the state of the United States, the language of the court is English. Okay? Everybody may speak English, but they are not English. So the court system that you have is rooted in English law because it's rooted in the English language. But the only problem is that the English people don't understand the law, which is written in English form. They're no better off than the foreigner going in the courtroom and they're saying, "Do you understand the charges brought against you?" And you saying, "Yeah," but you really don't. So as a result of that, you need an interpreter. Okay, and the reason why you need an interpreter is because the law is written in English. Okay, every pleading before courtroom is in English. If you don't speak English, they get an interpreter for you to speak it in your language so you can understand what's being said to you in English. And since you're in a courtroom, that will be complemented by the English common law. The law most useful to the people, i.e., the citizens. When we say citizens, we're not talking about those born on the soil, those who foreign and not became naturalized by the soil. Okay, we're talking about those who have a right to be on that soil because of their bloodline links to the soil back to the original contracting clause, which is in every state constitution except Virginia and the United States, which is the contract between we, the people of whatever state you're in, and Almighty God. And the language that's being spoken and to the people, not one individual, not two individuals or different nationalities, but the same people in society. If the people in society are different nationalities and speak a different language, when God's speaking to them, 9 times out of 10, you're not going to get that information. Okay? You're not going to understand what God is telling you to save you by the supreme law of the land, and that is the Constitution. So when we look in the Constitution, in every Constitution, especially New Jersey, it says, "We the people and Almighty God." That's the contract between the people and God, and a language that the people can understand them. So when you go to a courtroom, when you're reading the law, that's based upon the language of the law that the people who are governed by the law can understand them. If you don't understand English law, then you are confused as those who are not English. Okay? Because every English man and woman should know these fundamental principles about the common law. Okay? About the common law. That's very important that I'm saying that. All right? With that being said, I bring up the Pleading Act. Greetings, Archbishop Belmont from the House of Belmont. Glad you was able to join me. Greetings, Countess Joan. Glad you was able to join me. Pleading Act of 1362 by Edward I, okay, of the Plantagenet Crown. Okay, Edward I. The Pleading Act of 1836 rendered the statute of pleading was an act of the Parliament of England, not Ireland, not Scotland, or Ireland, but of England. The act complained that because of Norman French languages was largely unknown to the common people of England, meaning that prior to the Norman conquest, prior to the Norman invasion, prior to the Danish, Frankish, Nordic invasions, the common language of the people was what? English. Okay, this was passed by the government of the English people called Parliament. Okay, very important for you to understand that. So the act complained that because of the Norman French languages and every other language, all right, and every other language for that matter, all right, was largely unknown to the common people of England. They had no knowledge of what was being said for or against them in the courts, which used law of French. Okay, which read the law of French. That act therefore stipulated that all pleas which shall be pleaded in any courts whatsoever before any of his justices whatsoever, or in his other places, or before any of his other ministers whatsoever, or any courts and places of any other lords whatsoever within the realm, shall be pleaded, sued, defended, answered, debated, and adjudged in the English language. You hear that? In the English language. All right. This is Edward I of the Plantagenet Crown. Prior to the Norman conquest of England in 1066, traditional common law of England had been discussed in vernacular since time immemorial. Okay. So we know time immemorial starts with Richard I, son of Henry II, son of Godfrey V, kind of around Jew. But they're going back a time immemorial before that, because they existed in the 12th and 13th century before 1066 would be with the ancestors of the original Anglo-Saxons, which were the kings of Wessex. Okay, very important. So the vernacular since time immemorial and has been written in Germanic vernacular in Old English since circa 600 AD. Annos Dominus, the year of our Lord, beginning with the law codes of Ethelbert of Cambridge before the unification of the Anglo-Saxon tribe under what we call the Heptarchy. Okay, following the Norman conquest, the Anglo-Norman French language of the conquerors were used and developed into law French and was used for pleadings. Latin was used for the written record. The 14th century saw a decline in law French, hence the Pleading English Act, which marked the beginning of modern English. Everyone needs to understand this is why when you go to court, your pleading is in English. All right? Since we got that out the way, let's get to the nitty-gritty. Our review is to Trump versus CASA Incorporated. Let's review that before we go into the conversation that the Supreme Court is having in regards to the representation by the Solicitor General, okay, which is argued for on behalf of the United States. Let me just blow this up for you all can see it. Like, share, subscribe. Donate if you can. Free and common soakage. Trump versus CASA is a case argued before the Supreme Court of the United States on May 15th, 2025. That's this month. During the course October 24th and 2025 term. It was consolidated with Trump versus Washington and Trump versus New Jersey. Okay? Spearheaded by New Jersey. 20 states brought forth a complaint against Trump as a result of Executive Order 1060, 10, what is it? Executive Order 14, was it 1461? 10-1461, something like that. What is it? Give me a second. It should be right here. Executive Order. If I'm not mistaken, this is Executive Order 10. Let me just find it. Executive 14160. Executive Order 14160. That's the executive order that's before the Supreme Court right now. Okay? So let me go back here. Trump versus CASA. We're going to, that's on the Ballotpedia. All right, we're going to go to another, we're going to go to the actual executive order. I don't know if you all seen this, but you should pull it up. Executive Order 14160. This document is scheduled to be published in the Federal Register on January 29, 2025, and available online at https double slash federal register .government slash d.2025 dash 02007 and on https colon double slash government info.gov. Okay, so this way you can actually get the actual executive order yourself. And the executive order is about protecting the meaning and value of American citizenship. Okay, this is the executive order that's before the Supreme Court right now. And the Supreme Court don't want the executive order to be issued on behalf of the respondents, i.e. the defendants, okay? Spearheaded by, once again, the state of New Jersey. Why? Because they're trying to avoid what's coming down the pipe. Trump don't even know what's coming down the pipe because he's ignorant to the origin of law, okay? So he don't even know what's coming, but yet he's opened up Pandora's box. How we know? Let's see it for ourselves. Any question, please ask them. Protecting the meaning and value of American citizenship. Now, this is an executive order by the authority vested in me as president by the Constitution and the laws of the United States of America. It is hereby ordered. Section 1. The purpose. The privilege of the United States citizenship is a priceless and profound gift. Priceless. It's a gift from God. Okay? Very important. What God are you talking about? That's the importance of the priceless and profound gift of citizenship. Okay? Inclusive and exclusive. The 14th Amendment states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. So I mean, they're talking about the United States and the states. We know that the United States resulted from the states, okay? And prior to them becoming states, they were called colonies. And they had people there, all types of people at that particular time. Were they the original people? No, okay? Why? Because the original people at that time were those people that were in chains, okay? They were the people in chains. The provisions rightly repudiated the Supreme Court of the United States' shameful decision in Dred Scott versus Sanford. So this executive decision repudiate the shameless, harmful decisions impacted upon those identified as the African people who didn't have a race at that particular time. Okay? You didn't have a race at that particular time because Africans are not English people. Africans don't have the English language. Africans don't have the English law at their disposal. Okay, so we must be specific about the repudiating of the Dred Scott case in regards to when people identify with a race, but it's not African, because apparently you wasn't a citizen identified as an African. You can never be a citizen as African. When you read the 14th Amendment, it had nothing to do with Africans. It had something to do with a race of people that was classified as Africans, but they are not, for the record, African. Okay? Which misrepresent the Constitution as permanently excluding people of African descent from eligibility for United States citizenship solely based on their race. Okay, so we were not eligible according to citizenship based upon our race. Did y'all hear what I said? We were not included as citizenship because of our race, not of who we are, and not as who they identify us, because they said we had a race. Okay, very important to understand that. Okay, yes, African is not the name of the people. Africa is a name or another term for that continent. Okay, which is narrowed down to a specific time and era that culminated around the Atlantic slave trade. So according to the Dred Scott case, Dred Scott versus Sanford, it misrepresented the constitutional due process of law that citizens have. And it said it permanently excluded people of African descent from eligibility for ever becoming citizens of the United States solely based on their race. This is something that we cannot overlook. Why is this important? Because the Naturalization Act of 1790, which we'll draw from in a minute, clearly points to the classification for citizenship wasn't based upon race. It was based upon color of skin, such as white person or dark-skinned person or black people. Okay? That distinction must be made. The Naturalization Act was the first enactment of the United States for citizenship of 1790. Before that, you have to go to Calvin's case. Okay? Go back to Calvin's case. That dealing with the Stuart's descendants from the House of Stuarts, where does that go past the second generation? So the eligibility for citizenship, according to how they interpreted under the Naturalization Act of the Founding Fathers, we did not meet that requirement because it was solely based upon the color of skin, which we did not have their color. All right? Very important. We make that distinction. So when we're talking about race in regards to citizenship of African people identified Africans, that's not your race, but you do have a race, but you don't know it because the 14th Amendment doesn't specifically say your citizenship is based upon African rights, African laws, African Constitution, and they say anything of that magnitude. It said it must be construed to the common law of England in light of its history. Okay, that's what the 14th Amendment, in reference to what they said, United States versus Juan Kim of Art. Okay, very important, which we're going to go through. I don't know if we're going to do it in part 1 or part 2, but we definitely will go through it. It says, and it goes on to say, but the 14th Amendment has never been interpreted to extend citizenship universally to everyone born within the United States. The 14th Amendment has always excluded from birthright citizenship persons who were born in the United States but not subject to the jurisdiction thereof. So they're not talking about a race, okay? They're not talking about an ethnicity. They're not talking about genealogy. They're talking about the color of skin based upon the 14th Amendment, which is the process of some type of naturalization, okay? Some type of process of naturalization excluded from that process that involves those who have a just sanguineous relationship to that sovereign land, okay? Very important. So the 14th Amendment speaks about both statuses, just soil and just sanguineous. And just sanguineous only denotes to the English, Anglo-Saxon, Berbers versus just soil, which involves to anybody of any other nation other than America. Okay? Let's put that down for pointers. Let's continue. The 14th Amendment has always excluded from birthright, excluded, not included, from birthright citizenship persons who were born in the United States but not subject to the jurisdiction thereof. Consistent with this understanding, the Congress has further specified through legislation that a person born in the United States and subject to the jurisdiction thereof is a national and a citizen of the United States at birth according to Title 8 of the United States Code 1401, which mirrors the 14th Amendment. It's not the same. Okay? So when you're looking in the mirror, you better make sure that the reflection you get back is the 14th Amendment based upon the common law of England, going back to history of whether a common law originated from, or versus Title 8 United States Code Section 1401, which denote to or make synonymous the word national and naturalized. If everyone understand that, please give me a thumbs up in the chat line, because if you don't, you are in a world of trouble. Among the categories of individuals born in the United States and not subject to the jurisdiction thereof, privileges of United States citizenship does not automatically extend to persons born in the United States. Did you hear that? It does not automatically extend to persons born in the United States. One, when that person's mother was unlawfully present in the United States and the father was not a United States citizen or lawful permanent resident at the time of that said person's birth. Or two, when that person's mother presence in the United States at the time of said person's birth was lawful but temporarily, such as but not limited to visiting the United States under the auspices of a visa waiver program or visiting on a student, work, or tourist visa, tourist visa, and the father was not a United States citizen or lawful permanent resident at the time of said person's birth. We must understand that, okay? Just because you were born here does not make you a citizen. We know that America follows the law of partus sequitur beatrice, the status of the mother, not the father. If you're following the status of the mother, then it goes based upon you're going through the naturalization process by some type of formation implemented by some type of policy, which you see was Title 8, United States Code. What section was that? 1401? What section was that? Yeah, 1401. Title 8, United States Code 1401. All right, very important you understand that, because where I'm about to go for this now, it's going to hurt a lot of people. Section 2, policy. A, it is the policy of the United States that no department or agency of the United States government shall issue documents recognizing United States citizenship or accept documents issued by state, local, or other government or authority purporting to recognize United States citizenship to persons. One, when that person's mother was unlawfully present in the United States and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth. And mind you, they're only talking about just soil. They're not talking about you having relationships from some race, okay? Like these so-called people identified as African Americans. You couldn't be a citizen even as African American because they knew you were connected to some race. And when they emancipated you by the 13th Amendment, then they came the Civil Rights Act, then came the 14th Amendment. Once again, 13th Amendment, Civil Rights Act, 14th Amendment, okay? That's the line in genealogy how the citizenship clause work here in North America. When they emancipated us and gave us citizenship in regards to some type of civil rights, you had your choice. Was it going to be their civil rights, or which is a civil status, or the civil rights that's called political status that comes from your allegiance to your nation, your country, your nationality, your place of origin? Okay, these are called overseas rights of inheritance. Okay, this is clearly pointed out in United States versus Juan Kim Art. The citizenship precedents based upon how they construe it, which is under the common law of England, in light of the history, and it also tells you about the inheritance that comes along with that from Edward III as the Plantagenet and Crown, and it also shows you in that case that the founding fathers who helped overthrow the Anglo-Saxon folk right, which was the inheritance under Anglo-Saxon law, they took it for themselves in United States versus Juan Kim Art, but they're not going to tell you. They're not going to tell them. They're not going to tell the prosecution or the district attorney or the solicitor general or the district courts or the state courts or the Supreme Court because they don't want to let this out of the bag. But it's too late. How we know it? Let's continue to read. 1. When that person's mother was unlawfully present in the United States and the person's father was not a United States citizen or lawfully permanent resident at the time of that said person's birth. 2. When that person's mother presence in the United States, or when that person's mother's presence, where's that? Or when that person's mother present in the United States was lawful but temporarily, and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth. How you know you're not a citizen? Because the only instrument that you got in your pocket proves you're not a citizen because it says it on it that you're not a citizen. It says not real ID. Okay, and when you read a New Jersey statute, you know you're not a citizen because they register you with a military family because that's what the real ID stands for. Is a emblem that represents your relationship to those who die in military recognition. Okay, it's called the Star Family. Okay, it's either black or gold with a 5-pointed star in it. Okay, that's your citizenship. You are a corporation. States are corporation. The United States is a corporation. The president is a corporation. There's only 2 types of corporations, sole and corporate. So the sole is the corporation sole, i.e. the crown, i.e. the England, because England is a corporation. Parliament is a corporation. The king is a corporation. The king creates corporation by way of a charter. Parliament makes creation by way of a charter once they got the authority from the king. Okay, so that means, and rarely is of the latter, it's usually of the former, the king. That means that states, United States, or colonies, or any what we call proprietary corporation are all subject to that charter which was given. Okay, which we're going to discuss further on in this magnificent elaboration as we go on. So it goes on to say, B, subsection A of the section shall apply only to persons who are born within the United States after 30 days from the date of this order. So after 30 days of the enactment of this executive order 14, what was it? What was it? 14160, at 30 days from the executive implementation over of this executive order, the implementation of it comes into force. Okay, so I mean, from this point on, if the Supreme Court ruled in favor of Donald Trump, a lot of people are going to be what we call deported. A lot of people, and that meant those who are subject to just soil. They only started with the foreigners that they can prove are foreigners. Okay, they're coming for you next. That's why they have incarceration camps set up, not just for foreigners, but United States citizens as well. Because you're not governed under the 14th Amendment. That was exclusive for the emancipated slave. It said it in the opening of this first paragraph of this executive order. Okay? The other type of citizenship is governed under Title 8 United States Code, Section 1401. If everyone understands that, please give me a thumbs up in the chat line. Section C, nothing in this order should be construed to affect the entitlement of other individuals, including children of lawful permanent residents to obtain documentation of their United States citizenship. Section 3, enforcement. The Secretary of State, the Attorney General, the Secretary of Homeland Security, and the Commissioner of Social Security shall take all appropriate measures to ensure that the regulations and policies of their respective departments of agencies are consistent with their order, and that no officer, employees, or agent of their respective departments and agencies act or forbear from acting in any manner inconsistent with this order. Y'all don't hear me. B, the heads of all executive departments and agencies shall issue public guidances within 30 days of the date of this order regarding this order and implementation with respect to their operations and activity. This where it really gets interesting, because we know that under the Naturalization Act, the citizenship that they had, as well as those who are immigrants here under the Immigration Act, citizenship only deals with those who are naturalized. Whether you go through the naturalization process by way of being a resident, then going on to become a citizen, i.e. naturalized citizen under Title 8 United States Code 1401, or your citizenship comes under the 14th Amendment, okay? And that's different from just soil. The 14th Amendment is specifically dealing with race, ethnicity, genealogy, and for that, you must have a biological connection. It says, according to the definition of the executive order, where it deals specifically with race, like the people of or misclassified as African, which have a race but don't know it. Now you know it. Why? Because the only ones that are citizens, according to United States versus King Do or Sing, what is it? United States versus what is it? United States versus where's it at? Or Sing Tuck or King Do. Okay, we're gonna read all of this. All right. So it's a definition, section 4, as used in this order. A, mother means the immediate female biological progenitor. Did you hear that? Father means the immediate male biological progenitor. They're talking about a birthright inheritance, brothers and sisters. Not because you over here and you've been over here for a while and you got the right to sanctuary. No, it has nothing to do with that. And the Supreme Court is upset about this because I know more than they know about this problem that Donald Trump just started for him, because he specifically tailored the executive order for the original 10 of the 14th Amendment, which was exclusively for people of African slaves. Okay? So this is your emancipation, brothers and sisters. I am the shepherd calling my sheep. All right? You better support me. General provisions. Nothing in this order should be construed General provisions, section 5. My mouse is crazy. Forgive me. General provisions. A, nothing in this order should be construed to impair or otherwise affect point 1, the authority granted by the law to the executive department or agency or the head thereof, or 2, the function of the district of office of the managing and budget related to budgetary, administrative, or legislative proposals. B, this order shall be parcel. Yeah. Administrative or legislative proposal. B, this order should be implemented consistent with the applicable law and subject to the availability of the appropriations. All right? Of the appropriations. This order is not intended to and do not create any right or benefit, substantive or procedural enforceable at law or in equity by any party against the United States, its departments, agencies, or entities, its officers, employees, or agents, or any other person. So this is their immunity clause. This is their sovereignty clause. Even though this executive order was executed by the president on behalf of its citizens, if a citizen tries to sue the government, they have immunity as a result of that. But not in the case of an overthrow of the government under Title 18 United States Code 3485. Okay? An act to overthrow the government that was here prior to your government. If you set your government up, of course you got immunity, but not when the government was here prior to this enactment. Okay? Title 18 United States Code advocate the overthrow of government. We're going to discuss that, okay? Not right now, but now we're going to get into the argument raised in the Supreme Court in regards to the Executive Order 14160, okay? By Donald Trump. And it clearly said in the open paragraph, before I go off of this, the purpose of it. That is what it says. For all those who came in late. Section 1, purpose. The privilege is the privileges of United States citizenship is a priceless and profound gift. Okay, so what I'm saying to you should be priceless. Okay, you shouldn't just want to give it away. You giving it away. All right. The 14th Amendment, not Title 8 United States Code, Section 1401. It says the 14th Amendment. If y'all is not listening, then y'all gonna forever be dead. Okay. I'm calling you, I'm breaking you by understand that the 14th Amendment states that all persons born or naturalized is United States and subject to the jurisdiction thereof, and are citizens of the United States of the state wherein they reside. So before the Title 8 United States Code Section 1401, they had the 14th Amendment, and then the 14th Amendment it covered two grounds. It covered just soil and just say greening. So it left a choice up for us to either become citizens like they are, i.e., either being born subject to the jurisdiction thereof, or open our eyes and see that there was another door or another window of opportunity that they had. They couldn't just upright and tell us. It was your choice to be awakened. Okay? And if you're not listening to me, then of course you chose not to be awakened. Okay? So with that, let's get into the Supreme Court ruling or the arguments. Esquire, you should be shaming yourself. I told you to be on time. Before that, let's go to the appellate court. Let's go to the appellate court brief. United States Courts of Appeals for the First Circuit. This is a district court, brothers and sisters. United States Courts of Appeals for the First Circuit. State of New Jersey, 1. Commonwealth of Massachusetts, 2. State of California, 3. State of Colorado, 4. The state of Connecticut, 5. The state of Delaware, 6. District of Columbia, 7. State of Hawaii, 8. State of Maine, 9. State of Maryland, 10. Attorney General Dianne Nessel on behalf of the people of Michigan, 11. State of Minnesota, 12. State of Nevada, 13, state of Mexico, 14, state of New York, 15, state of North Carolina, 16, state of Rhode Island, 17, state of Vermont, 18, state of Wisconsin, 19, and city and county of San Francisco, 20. Did you hear that? 20 states going against the executive order implemented by Trump, executive order 14160, and the appellates, all right, it's the state of New Jersey and all these other states against Donald Trump. They responded, or what we call the defendant, okay? Because they're the one complaining that the executive order is unconstitutional, all right? Very important. There you go. Matthew J. Plankett, Attorney General for New Jersey. All right. March 11th, 2025. All right, here we go. Baron Chief Judge, defendant appellant, the government moved for a stay pending appeal of February 13, 2025, ordered by United States District Court for the District of Massachusetts. So the District Court ruled in favor of Donald Trump. The appellants filed a motion to stay, which was denied by the appellate court, and then they part itself that was upheld by the appellate court, and then Donald Trump filed a review for the Supreme Court in regards to the appellate court overturning what the district court declared. Okay, so it says defendant appellant the government moved for a stay pending appeal of February 13th, 2025 order by the United States District Court for the District of Massachusetts. District Court order granted a universal preliminary injunction. Okay, this is a nationwide injunction. It's called a Bill of Peace to the 18 state plaintiff states, including Massachusetts, in their suit challenging enforcement of Executive Order number 14160. Okay, titled Protecting the Meaning and Value of American Citizenship Executive Order. And we just read the order for ourselves. Okay, the executive order limits in two circumstances the person whom federal officials may recognize having United States citizenship based on having been born in the United States. The first circumstances in which that person's mother was unlawfully present in the United States and the father was not a United States citizen or lawfully a permanent resident at the time, part itself. Now the permanent resident, permanent, find it. The District of Columbia and the City of San Francisco are plaintiffs. The time of said person's birth, the second circumstance is when the person's mother presence in the United States at the time of said person's birth was lawfully but temporary. Oh, come on. Lawful and temporary. And the father was not a United States citizen or lawful permanent resident at the time of that said person's birth. This complaint alleges that the executive order violates the citizenship clause of the 14th Amendment to all United States, to the United States Constitution, provides that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. Let's see what else. All right, so from that, that's pretty much what was said in the executive order, which we read at the start. So now we're going to go to Supreme Court argument that's before the court, which is live, and it's the Solicitor General taking questions from the Supreme Court on regards to they're claiming that it's constitutional and that the Supreme Court lacks jurisdiction to enter preliminary injunctions on behalf of a class or a class of people. And it said that there are uh, relief set up under Rule 23, which deals with class action suits. Okay, and they're saying that the preliminary injunction, worldwide injunction, could not be implemented on the Trump or any of his executive officers as a result of Article 3. Okay, the executive power of the president. Okay, and his cabinet. So with that in mind, let's go to the actual video, and we're going to draw from that. So I'm going to stop it. Once they say a couple of things, we're going to break it down and revisit some of the arguments that's being raised so that we can have a clear sight of what it is that they're not telling you about this case. With that, let's get started with this marvelous lesson. Here we go. All those who have a hard time hearing, they got the words up there so you can see it. Okay. Let's get to it.
4A884, Trump versus CASA Incorporated. And we will hear argument this morning in case 24A884, Trump versus CASA Incorporated, and the consolidated cases. General Sauer.
Mr. Chief Justice, and may it please the court. On January 20th, 2025, President Trump issued Executive Order 14160, protecting the meaning and value of American citizenship. This order reflects the original meaning of the 14th Amendment, which guaranteed citizenship to the children of former slaves, not to illegal aliens or temporary visitors.
Did y'all hear that?
Multiple district courts promptly issued.
Did you hear that? All right, let me just go back a little bit more.
Nationwide or universal injunctions blocking this order.
We will hear argument this morning in case 24A884, Trump versus CASA Incorporated, and the consolidated cases. General Sauer.
So the cases were consolidated, okay? All the cases that were raised in the district court, circuit court, and the appellate court, based upon all parties, were all consolidated and were brought before the Supreme Court, which you're hearing their arguments now, okay? Represented by Solicitor General John Sawyer. Okay, here we go.
Mr. Chief Justice, and may it please the court. On January 20th, 2025, President Trump issued Executive Order 14160, protecting the meaning and value of American citizenship. This order reflects the original meaning of the 14th Amendment, which guaranteed citizenship to the children of former slaves, not to illegal aliens or temporary visitors.
Okay. Not to legal aliens or temporary visitors, okay? Temporary visitors are legal aliens, okay? We understand that the 14th Amendment, it didn't say nothing about Title 8 United States Code Section 1401, and they said that the original intent of the 14th Amendment, not what other purposes they created from the original intent, okay? That has to sink into everybody's head about the original intent of the 14th Amendment, which clearly Donald Trump said it was for the children of the former emancipated slaves. So this is your inheritance that Donald Trump is implemented without him even knowing it, that this is your birthright, okay? Because under the 14th Amendment, when you construe it to United States versus One Kim Ark versus all the other cases, Enri Ahmad Hassan, Bhagat Singh versus Bhagat Singh Ding, as well as United States versus King Singh, which we're going to go through. We're going to see that the true American citizens, the one who have the right to inherit it over here without any test whatsoever, are the Anglo-Saxons, which are of darker complexion, if you want to deal with to play the color game. Okay, so let's get it.
Multiple district courts promptly issued nationwide or universal injunctions blocking this order, and a cascade of such universal injunctions followed. Since January 20th, district courts have now issued 40 universal injunctions against the federal government, including 35 from the same 5 judicial districts. This is a bipartisan problem that has now spanned the last 5 presidential administrations. Universal injunctions exceed the judicial power granted in Article 3, which exists only to address the injury to the complaining party. They transgress the traditional bounds of equitable authority, and they create a host of practical problems. Such injunctions prevent the percolation of novel and difficult legal questions. They encourage rampant forum shopping. They require judges to make rushed, high-stakes, low-information decisions. They circumvent Rule 23 by offering all the benefits but none of the burdens of class certification. They operate asymmetrically, forcing the government to win everywhere while the plaintiffs can win anywhere. They invert the ordinary hierarchy of appellate review. They create the ongoing risk of conflicting judgments. They increase the pressures on this court's emergency docket. They create what Justice Powell described as repeated and essentially head-on confrontations between the life-tenured and representative branches of government. And they disrupt the Constitution's careful balancing of the separation of powers. I welcome the court's questions.
Okay, so Solicitor General is telling the Supreme Court judiciary or judicature that they don't have the power based upon the power implemented under Article 3, and that that they do have immunity to enact new executive orders based upon the powers it gave under Article 3. And he's letting them know that the original enactment of the 14th Amendment in regards to classes of citizenship playing the game they play is kind of loosely argued as a result of they're not really identifying citizenship as it truly means in regards to the two types of citizenship governed under the 14th Amendment, just so and just say green. So the Supreme Court and Solicitor John Sawyer is going to clearly, totally contradict what United States versus Juan Kim Ark was. They're going to mention it, but don't go and dive deep to what United States versus Kim Ark says, because if they do, then they're going to have to go back to the argument based upon race of those African people identified at that time. The founding fathers started their government, and at their time, we weren't considered part of what they classify as citizen because that was based upon the color of skin. Okay, when it should have been based upon race, which clearly they said we had one. Okay. We just didn't know what it was, all right? And this is, they're telling on you because when you study United States versus Juan Kim Ark, what they're going to mention, it mentions not just the origin of the common law of England concerning birthright citizenship, but who originated those laws, okay? That law originated from the English-speaking people, okay? Very important you understand that. Let's continue.
General Sauer, these universal injunctions, as you say, have proliferated over the last 3 decades or so. Would you discuss, though, the origins of universal injunctions? In particular, I'm interested in sort of historical analogs or the historical pedigree, particularly the Bill of Peace that was proffered by respondents.
Yes, Justice Thomas, as you, I think, first pointed out in your separate opinion in Trump against Hawaii, the Bill of...
Before they talk about the Bill of Peace and universal injunction, okay, from the arguments made by Solicitor John Sawyer, based upon the question brought forth by Chief Justice Thomas, let's just look those terms up so we can identify what it is that they're saying. Because if you didn't, you'll be lost in the sauce. Bill of Peace. The Bill of Peace was an English court practice used in the 17th, 18th century for legal disputes involving multiple parties that shared common aspects. It allowed English courts of chancery, i.e. chancellor, okay? The first chancellors originated as chancellors were the governors, and that was Lord Cornbury and William Franklin. Enway versus Chancellor. They were the ones who set the standards for the judicature. They picked the Associate Justice, Chief Justice, as well as those for the Chancery Court. So if you don't go back to the origin in regards to that standard, which was under the Crown, because he was under the royal authority of the Crown at that time. It was a fusional government. And the King was in charge of the legislative, i.e. Parliament. He was in charge of the executive department, i.e. What we call the executive branch, and in charge of the judiciary, i.e. the King's bench, okay? And that's confirmed by Bellin versus Harris and Barber versus Barber, which we're going to look further into through the course of this review. So it says that it allowed English courts of chancery to settle the rights of parties, a group known as multitude, in one suit in equity court. This is called a class action suit. If the equity court allowed the matter to proceed as a bill of peace, the result of the suit will bind all members of the multitude, whether they actually appear in the case or not. Okay, this is what Chief Solicitor was saying about the Bill of Peace. All right, the nationwide junction that the state wanted the Supreme Court to enter on behalf of the appellants was being argued before the Supreme Court because Solicitor what's his name, Sawyer, what was his name? The solicitor felt as though that under executive orders enacted by the president, that they were able to deal with it on a case by case. Okay, and Supreme Court then challenged him on that, saying that it can't be dealt with on a case by case. That means that everybody who's been affected by uh, 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 injury by the state, they each had to file individual claims, whether they're class actions or not, when it could just be done and over with, affecting all parties associated with that class of people. Okay, this is the argument for that court. Okay, and we're also looking at nationwide injunction. Matter of fact, let's go back to Bill of Peace. Bill of Peace. The bill was limited to until 1873 equitable relief, including an injunction and accounting on types of declaratory judgment called a decree. Okay? Very important for us to understand that. Where is the origin of that stem from? The origin of the Bill of Peace practices as well as class action lawsuits may be centuries earlier, beginning at the early of 1309, and the decision of the English Quasi-Judicial Council known as the General Erie. The General Erie. That's called the what did I do? That is called what we call articles of called the articles of RE. Let's look at that real quick before we go back to the lesson. Articles of RE, where the Bill of Peace comes from. Okay. The officers or coroners were formally established in England by Article 20 of the Articles of RE in September 1194 to keep the pleas of the crown. You hear that? Pleas of the crown. All right. This was by way of what we call a petition. We can see that in United States versus Lee and Chisholm versus Georgia. The only way you can sue on behalf of in regards to a complaint bringing forth to the crown or the United States, that petition goes back to that as designed by Edward I of the Plantagenet Crown, which we're going to see further on through this lesson, whether part 1 or part 2. But as we can see, the Erie of 1194 was initiated under the Hubert Walters justiciarship to restore world justice following the anarchy of Prince John's Rebellion, when began the anarchy. All right, yeah, King John, the anarchy, which began with Richard I. This is where the concept of time memorial come from, was detained in transit from the Third Crusade. Within 2 months, justices of Erie had visited every shire, which means county in England. Local knights were appointed as coroners to record crown pleas to be presented to the justices. The motivation of this administrative reform was need to raise money for King Richard's reconquest of Normandy. Okay, Normandy was the Norman conquest done by William the Conqueror. Prior to that, we was all under our own governmental structure, governmental laws, governmental customs, etc. Okay, so we see that the Bill of Peace originated from the Articles of Erie, which started with Richard I of the Plantagenet Crown, which we are, in fact. Okay, a corporation incorporated from the prior corporation, which we have all the rights transferred over. Okay, very important. And now we have what we call a universal or nationwide injunction. Let's look at that real quick. Nationwide injunction. This is sought in Chancery Court. The United States law, a nationwide injunction, also called universal injunction or national injunction, is an injunctive relief, which is a deferment relief, in which a court binds the federal government, even in relationship with non-parties. Okay, so you don't have to be a party to a nationwide injunction. In their prototypical form, nationwide injunctions are used to restrict the federal government from enforcing a statute or a regulation, especially when it comes to the First Amendment. Okay? And we know in the First Amendment, there is no test for holding a public office such as mine. Okay? Very important. The history. Professor Samuel Bray said the common law equity practice includes nothing remote like a national injunction. While groups of prominent legal historians more narrowly concluded that no modern style nationwide injunction issue at common law. Courts did not have it. Courts did have the equitable power to enjoin defendants with regards to the plaintiff, but typically not the world at large. Okay, in cases which multiple parties had a common claim against the same defendant, the British Chancellor or the English Chancellor sometimes offered a remedy known as a Bill of Peace. Why was this given by the Chancellor known as the Bill of Peace? Because the Bill of Peace was to keep what? The King's peace. Okay? The King's peace. This is called peace law. Okay? Peace law. How many of you know about that? All right. Apparently, they don't know about that, but they're talking about a bill of peace and a nationwide injunction. If anyone deserves that, it is the Anglo-Saxon Berbers. Okay. The legal term, peace law. Let's see. The legal term, peace law. The legal term peace, sometimes King's peace or Queen's peace, is a common law concept of maintaining the public order. The concept of the King's peace originated in Anglo-Saxon law, hence folk law. United States versus Warren Kim Ark said that the founding fathers took that folk law for themselves, okay, where it initially applied to special protection according to the household of the English kings and their retainers. A breach of the King's peace would conclude be either a crime or a tort, which was a serious matter. You hear that? So that meant that if you broke folk right, you were in violation of the King's peace. What is Anglo-Saxon law? Because it just said that. Let's look at Anglo-Saxon law. See, the Supreme Court, nor the Solicitor General, nor any of the states, okay, know this. None of them know this. Anglo-Saxon law. Anglo-Saxon law was the legal system of Anglo-Saxon England from the 6th century until the Norman conquest of 1066. We go back to the Pleading Act of 1362. Prior to that, the common law was England till the Norman conquest, which became Norman French law until the Pleading Act of 1362 by Edward I of the Plantagenet Crown. Anglo-Saxon law means decree or judgment. This is the day of judgment, brothers and sisters, was the legal system of the Anglo-Saxon England from the 6th century until the Norman conquest of 1066. It was a form of sort of Germanic law, i.e., that's what they call us, barbarians, okay? German law based on an unwritten custom known as folk right and on the written law enacted by the king with the advice of their written or council. This is why New Jersey's provincial council was called His Majesty's Council, i.e., His Wise Council. Okay, Wittemont. No different than what the 1911 Encyclopedia Britannica says, that the Berbers government was Wittemont, okay? And the uncoded law was called what? The Magna Carta, under what we call folk right. Now we go to United States versus Warren Kim Ark before we go back to the Supreme Court indulgence. Look at what Warren Kim Ark says about the birthright of the Anglo-Saxons, which was stolen by the founding fathers. I didn't say that. United States versus Warren Kim Ark said it. But you don't want to be English, though. All right? It says here, you can look it up on Wikipedia. Go to page 169 U.S.709. That's a pointer. It says, to what nation a person belongs is by the law of all nations closely dependent on a descent. You hear that, y'all? A descent. It is almost an universal rule that the citizenship of the parents determines it. That of the father, whether children are lawful and whether they are bastards, that of their mother. So you see the executive order mentions both, okay? Biologically, okay? Now we see in United States versus Warren Kim Ark talking about the nation and citizenship in regard to the nation don't come from some type of naturalization process. It don't come from some immigration process. It don't come from just being attacked or related to based upon the color of skin. It has to do with your descent, your ethnicity, your genealogy, your race. I didn't say that United States versus Warren Kim Ark. He's a Chinese. He ain't English. So he didn't classify under the 14th Amendment in regards to just sanguineous. He did classify under just soil, okay? All right? Because he deserved citizenship under just soil, not because he had a right of inheritance of the soil, okay? So as it said, to what nation a person belongs is by the law of all nations, culture depending upon the descent. It is almost a universal rule that citizenship of a parent determines it. That of the father where children are lawful, and that of the mother where children are considered bastard, i.e. partus sequitur, being trim. And of the mother without regard to the place of birth. You hear that? And that must necessarily be recognized as the correct canon, since nationality is in the essence dependent upon descent. Okay? Depends upon descent. The framers of the Constitution were familiar with the distinction between Roman law and feudal law. Now listen to what he said. The framers' Constitution was familiar, so they understood Roman law, right? And we know Rome invaded England, all right? Then they said, as well as feudal law, and William the Conqueror invaded England. So these are two conquerors, the Romans and the William the Conqueror, okay? But it all goes back to the same religious affiliation, i.e. the Roman Catholic Church, okay? And it said that the framers of the Constitution were familiar, okay, with the distinction between the Romans law and the feudal law. Not English law, but feudal law. So that meant that they knew the distinction between those two, and we know that feudal law and Roman law is not English law, okay? Between the obligation based on the territoriality and those based on the personal and indivisible character of origin. And there is nothing to show that in the matter of nationality, they intended to adhere to the principles derived from the regal government, which they had just assisted in overthrowing. So the founding fathers had just assisted in overthrowing the regal government, okay, and those who were citizens or subject of the regal government based upon the laws of descent, because their intent for citizenship was based upon the color of a skin, okay? And that only included white people, because African Americans were not included based upon the Executive Order of 1601. Okay, if everyone agrees with what I just said, please give me a thumbs up in the chat line. Manifestly, when the sovereignty of the crown, listen, y'all, listen, they just said they helped overthrow the regal government that was already in place by overthrowing it, okay? And then they said, manifestly, when the sovereignty of the crown was thrown off after they overthrown it and the independent government was established, every rule of common law and every statute of England obtained in the colonies, you hear that? And derogation of the principles on which the new government was founded, it was abrogated. Did you hear that? It was abrogated. The states, for a national purposes embraced in the Constitution, became one, united under the same sovereign authority and governed by the same laws. But they retained their jurisdiction over, this is where the slavery comes in, y'all, but they retained their jurisdiction over all persons and things within their territorial limits, except where surrendered to the general government or restrained by the Constitution and protection of what? Life, liberty, and property, and rested primarily with them. So far as the just commune and the folk right, which we know is Anglo-Saxon law in the first paragraph, related to the rights of persons was concerned, the colonies regarded it as their birthright and adopted such parts of it as they found applicable to their condition. Did y'all hear what I just said? So the folk right or the just commune means the crown, okay, which is the crown land, because crown land is intel land, which is inheritance. They took it for themselves after they overthrew the crown, which they just submitted, not the British crown, but the English crown, because the English crown was called the Provincial Council here in 1702 to 1776 when they locked up William Franklin, the world governor and chancellor, who gave instructions to all the associate chief justices as well as the courts of chancery, which we're going to see stated in Brennan versus Harris, as well as Barber versus Barwick, which we might do it in this part one or part two. I haven't decided yet. But now let's get back to the video, to the Supreme Court case. We got a couple of more minutes. I'm going to end this at 9 o'clock, so we got about 10 minutes. Greetings, C.A. Murphy. Glad you were able to join me, brother. Everyone leave a comment in the comment box as well as in the chat line once this lesson is over. Let's see.
These universal injunctions, as you say, have proliferated over the last 3 decades or so. Would you discuss, though, the origins of universal injunctions? In particular, I'm interested in sort of historical analogs or the historical pedigree, particularly the Bill of Peace that was proffered by respondents.
Yes, Justice Thomas, as you, I think, first pointed out in your separate opinion in Trump against Hawaii, the Bill of Peace is something very distinct from a universal injunction. So the Bill of Peace involved a resolution of a small, discrete set of claims of a small, discrete group. And even more fundamentally, it was binding on the members of that class and those represented by the class. So it's much more analogous to a modern class action under Rule 23. And in fact, as we've argued in other cases, and as this court has described in opinions like Ortiz, the Bill of Peace evolved into and is directly developed into, so to speak, the modern class action that has all the same features of a Bill of Peace. So in the words of Chief Judge Sutton in the Sixth Circuit, the Bill of Peace, it was a domesticated animal that looks nothing like the dragon of a universal injunction.
I'm sorry. Here, there's a discrete identified group on one issue. Does citizenship mean, are you born in the territory of the United States? Or does it mean, are you loyal to someone else, which is your claim? Or are your parents loyal to someone else? So that's no different than what happened in a Bill of Peace. The United States is bigger, so it extends more broadly, but it's still an identifiable group on a discrete, singular question.
And Your Honor, I'd say 3 things in response to that. First of all, our primary contention is that the citizenship clause related to the children of former slaves, not to illegal aliens who weren't even present as a discrete class at that time. But
you hear that? You hear that? None of them are focusing on what the executive order was really intended for, because they don't want to touch on that, because they know if they do, they'll be in a world of trouble. This is why the Supreme Court is trying to shut that down, because Solicitor General is saying too much, but don't have enough understanding about what it is that he's saying. Supreme Court knows what he's saying that he's not saying, that he don't understand, but they ain't gonna say it. Why? Because they don't want to let the cat out the bag. Okay.
But more fundamentally here, as to the issue of the Bill of Peace, there are critical differences. The Bill of Peace was a binding judgment that would bind absent class members. Here we have the asymmetry.
Well, here, class actions don't bind anyone who opts out. So class actions are not like bills of peace.
I would think that a Rule 23b2 class action, which would be the relevant analog here, would be one that would be binding on absent class members and would not have the same notice and opt-out procedures. And more fundamentally, that sort of argument that there's a commonality here among all the people who purport to be affected by this is the sort of argument that's made in class certification.
So can I ask you a question? Your theory here is arguing that Article 3 and principles of equity both prohibit federal courts from issuing universal injunctions. Do I have your argument correct?
We argue both of those. And
you argue both of those. Yeah. If that's true, that means even the Supreme Court doesn't have that power.
The Supreme Court would have the authority to issue binding precedent nationwide, but
we couldn't enforce it against universally, is your argument.
If there was a decision that violated the precedent of the court, then the affected plaintiffs could get a separate judgment.
And that means you're talking about the hundreds and thousands of people who weren't part of the judgment of the court. They would all have to file individual actions?
Not necessarily.
Or a class action.
A class action would be
that makes no sense whatsoever.
Respectfully, we believe that.
Well, what was the purpose of the Bill of Peace if not to settle a legal question finally? And if even the Supreme Court doesn't have that right and must invite hundreds of thousands of lawsuits What are we buying into?
All right. Now she's letting them know that these Article 3 under the executive power of the president and his cabinet, they have the right or the immunity to not be bound by, as you said in the executive order, they have some type of immunity if a claim was brought against them. Okay, so now the argument is now if a group of people are affected by the executive order, would they have the right to seek remedy by way of a nationwide injunction? Solicitor General is saying that no, there already a criteria set up on the Rule 23 that there were class actions to settle those disputes based upon those group of people who fall under a certain classification. And what the Chief Justice is saying is that it's not the same. Because if each one has to follow Rule 23 in regards to class action suits, then there's a bunch of class of people out there that fall in different type of classes, that each and every class has to file a lawsuit based upon Rule 23, and that the state or the government is free to violate the other people's rights until they bring a class action suit based upon Rule 23. That's what they're saying. Okay, for all those who don't understand the terminology.
If a set of claims satisfies the rigorous criteria of Rule 23, Rule 23 is the modern analog of a bill of peace. We have something very different here.
No, but we don't, because the argument here is that the president is violating an established, not just one, but by my count, 4 established Supreme Court precedents.
Listen, y'all.
We have the Juan Ark case.
Okay. She mentioned Juan Kim Ark, and she ain't gonna say shit about what we just talked about in Juan Kim Ark. They don't want to talk about what Juan Kim Ark. This was gonna come out if either or. Whether they pass the executive order, if they don't pass the executive order, it's still gonna work in our favor. Okay? They just don't want it to come out because of the origin of where the whole argument about citizenship stems back to. Okay? They know they ain't citizens based upon just saying having the right to be here. Okay? Now these executive orders are doing away with that because now Trump is dealing with descent, race, ethnicity, and that's not how the government that was set up by the framers intended it to be. It was based upon their color of skin. Okay? Very, very important to understand what's being said. She mentioned Juan Kim Ark, and Juan Kim Ark talked about the inheritance of Anglo-Saxon people. Okay? English people. Let's continue.
Where we said fealty to a foreign sovereign doesn't defeat your entitlement, your parents' fealty to a foreign sovereign doesn't defeat your entitlement to citizenship as a child. We have another case where we said that even if your parents are here illegally, if you're born here, you're a citizen. We have yet another case that says even if your parents came here and were stopped at the border, but you were born in our territory, you're still a citizen. And we have another case that says even if your parents secured citizenship illegally, you're still a citizen. So as far as I see it, this order violates 4 Supreme Court precedents.
Yeah,
and you are claiming,
when in fact it don't violate the presence of the United States versus Juan Kim Ark. It actually assists the presence of Juan Kim Ark. They ain't raising an argument that they should be raising in Juan Kim Ark that supports what Trump's saying. They trying to shut that down ASAP. If everyone understands that, please give me a thumbs up in the chat line. They don't want to address Juan Kim Ark based upon the true meaning of Juan Kim Ark, based upon the common law of England and the history of the common law in light of the citizenship where it originated from. They want to deal with it from the 14th Amendment perspective that all other persons born on the soil were citizens. Trump is trying to shut that down. He's saying, no, you're not. And he's in fact right. Okay? He is 100% right. You do not have a right to be here. Hell, even they don't have the right to be here because of the Nationalist Act of 1790. Why? Because it does not denote to you having a descent. Okay? Trump know it. They know it.
that not just the Supreme Court, that both the Supreme Court and no lower court can stop an executive from universally from violating those holdings by this court?
We are not claiming that because we're conceding that there could be an inappropriate case.
Only a class, only
Can I hear the rest of his answer?
She keeps shutting them down.
23 class action. And then the more fundamental point as to all those Supreme Court decisions you referred to.
So what do we do temporarily?
Temporarily, the court may issue, the lower courts may issue injunctions that remediate the injuries to the plaintiffs that appear before them. Lower courts in appropriate cases may certify.
So when a new president orders that because there's so much gun violence going on in the country, and he comes in and he says, I have the right to take away the guns from everyone, then people, and he sends out the military to seize everyone's guns. We and the courts have to sit back and wait until every named plaintiff gets, or every plaintiff whose gun is taken comes to court.
In appropriate cases, courts have certified class actions on an emergency basis. We found at least 4 cases in recent years where that was done. But more fundamentally, we profoundly disagree with the characterization of the merits. This is now fully briefed in the Ninth Circuit in case number 25-807, where we describe how that characterization of the holding of Wong Kim Ark and the other decisions is profoundly incorrect.
What? You said the holders of Wong Kim Ark are incorrect. See, none of them know what they're talking about. None of them know what they are talking about. Especially when you're talking about birthright citizenship, because that was never their undertaking. Okay? It was never their undertaking. So with that, I'm going to show you one case law to close out on. And that's United States versus what's this? United States versus Sing Tunk or King Do. I'm gonna close that on this, and we'll pick up tomorrow, same time, same channel, 7:30. United States versus Sing Do or King Do. But it is said that the applicants did not prove before the immigration officers that they were citizens. that simply they alleged that some simply alleged the fact, while others said nothing. That they were told that if they would give the names of 2 witnesses, their testimony would be taken and considered. Well, what provision of law is there for compelling the attendance of witnesses before such immigration officer, or for taking dispositions of what avail would be ex parte inquiry of such witnesses? Must an American citizen seeking to return to his native land be compelled to bring with him 2 witnesses to prove his place of birth, or else be denied his right to return and all opportunities of establishing his citizenship in the courts of his country? ? No such rule is enforced against an American citizen of Anglo-Saxon descent. Did y'all hear that? No such rule is enforced against an American citizen of Anglo-Saxon descent. And if this be as claimed a government of laws and not of men, I do not think it should be enforced against an American citizen of Chinese descent. Remember, Anglo-Saxon descent is based upon the citizenship of America. Chinese descent, as we've seen in Wong Kim Ark, did have citizenship, but it was just upon the base of just soil. Okay, so there is a difference. And we see the Executive Order 14160 is not based upon just soil. It's based upon just sanguineous, meaning you must have a race. So with that, make sure you all be here for part 2 tomorrow. All right. Like, share, subscribe, donate if you can, as well as leave comments in the chat box as well as the comment box. And hopefully this will make sense to you all in regards to understand that if you have a birthright here, you better know who your mothers and fathers are. Okay? I'm not talking about the immediate ones. Okay? So with that, I'm going to greet you as I always greeted you. And that's in peace and love. Are there any questions before I go? Please post them now. Are there any questions before I go? Any questions? No questions? So everyone should be on point. All right. You're right, Brother McGarrett. A chain of events that's going to affect them all. They don't know what's coming. They do not wait to part two. I'm going to show you that they don't know what's coming. What's coming is us. All right. I'm going to connect all this in part two. Okay. So make sure, like, share, subscribe. Those who don't know about this channel, they need to be watching these two videos. Okay. Part one, which is today, and part two tomorrow at 7:30. Okay. So with that, thank you all for attending. I see you and I greeted you as well as I always say, in peace and love. Peace.